got Andrew today again with us. So this is the second time Andrew is joining us. First of all, thank you so much, Andrew, for joining us today.
Thank you. Thanks for having me. I'm happy to be here and always happy to connect with your followers and hopefully teach them something and learn something.
Awesome, awesome. So you always provide a lot of value. So they're looking forward to listen and hear from you, and hopefully take your advice. So Andrew, before we kind of take a deep dive down today into the shareholder agreement, because this episode is just focused on shareholder agreements, right? I'm sure because this is such an important document in any business, it can change or make or break a business, right? Because it's so central, right? But before we dive down deeper into it, Andrew, why don't you give kind of a brief introduction for the people who don't know you?
Great. Well, my name is Andrew Chudnovsky. I'm a corporate lawyer based in Toronto, but I have clients across the country. I work kind of half the time in the transactional space, so small, mid-cap business M&A, merger and acquisitions. So a lot of transactions in Canada with those types of those sizes of transactions. And then the other half of my time is spent a lot with kind of new startup based high growth potential clients, as well as some old school kind of brick and mortar clients as well. And we do the kind of day-to-day corporate work as well as your early stage structural corporate structural work, which is kind of what we're going to be talking about today as far as shareholder agreements go.
Awesome, awesome. And so all the clients you work with, Andrew, they have a common element, and that is a shareholder agreement, right? In one way or shape or form, all of these businesses have shareholder agreements. So let's start
Yeah.
with it. First, what are the key elements of shareholder agreement, and why is it important to start off?
Sure. Well, I think let's start at the very beginning, so we understand what a shareholder agreement even is. And a shareholder agreement is now they're usually a unanimous shareholder agreement. So a USA, as you may hear me refer to it as, is a unanimous agreement among the shareholders about certain aspects of the management of a company, the flow of capital, so payment of dividends, for example, dispute resolution processes, whole, buy-sell agreements and shotgun provisions. Those are all some terms you might have heard before. And really what it is the shareholders at the highest level of owner of corporate structure coming together and coming to an understanding about how certain things are going to be dealt with in the future. So a shareholder agreement, well, in every single province and then federally, corporations are governed by the corporate statutes. So in Ontario, where I am, the Ontario Business Corporations Act, that's your kind of base level of legality surrounding how corporations operate. Now,
Okay.
the act itself allows companies to take some of the provisions and actually limit them or expand on them. And it's basically saying you as a shareholder can enter into a contract with your other shareholders about ignoring certain things of the OBCA or adding to certain things of the OBCA, effectively saying you as a business owner can do things the way you want to do them. For the most part, there are certain parts of the OBCA that you can't contract out of, but that's kind of the overarching kind of area in which the shareholder agreement exists in. So a shareholder agreement is a contract between shareholders. Oftentimes, the standard corporate structure is you have shareholders at the top. They own the capital. They own the business. They then elect directors. Directors oversee the high-level management of the business.
Yeah.
And under the directors, you have officers, senior management, C-suite, stuff like that. That's very common, obviously, out of by law in public companies, but in private companies and privately held companies, even if there's only two shareholders and they both act as directors, the reality is those three structures, those three kind of organizational structures are there. And what a shareholder agreement does is kind of set the stage for how everything underneath acts. So that's kind of your very quick introduction to governance of a shareholder agreement. And then the reason they're so important is because what you're trying to do is limit uncertainty in the future. You're trying to agree on certain points of management, decision making, um, capital flow, just like I said, dispute resolution, all these things now to avoid situations in the future where, let's say you have a 50-50 ownership between two founders and you don't have a shareholder agreement that talks about some of this. Well, what happens when there's a disagreement?
Mm,
Nothing can happen because certain decisions require the shareholders to vote. If you can only get 50%, you don't have a majority of the vote. Therefore, you can't actually do anything. And a company can be, completely handcuffed because of deadlocks among the shareholders. So that, a shareholder agreement's there to try to limit the risk of that happening.
okay. So excellent point, right? Like, part of it you touched on Ontario and being like, jurisdiction, right? So explain it a little bit more for the people who have federal corporation versus provincial, right? How does that impact a shareholders agreement?
Generally, it doesn't. Without getting too nitty gritty, the provincial acts tend to mirror the federal act, and so there's not a lot of from my perspective in my practice, it's pretty rare that we have an issue with having to deal with kind of differences in provincial statute,
Yeah.
vis-a-vis the shareholder agreement. These are agreements that kind of exist across the country, no matter where you're incorporated, really.
Okay. Okay. So talk about like, how about like, what does a shareholder agreement have a say under like decision making and voting rights in a company?
Right. So by law, the kind of standard, if you think about, let's just talk about kind of common shareholding here. So, some of the viewers may know that there are, and some may not, that there are different classes of shares. Each class of share has different rights. Those rights are written in the excuse me, in the articles of the company, the articles of incorporation. But the most basic kind of shareholding is a common shareholding. So it's when you hear someone say, oh yeah, we're 50-50, that probably means they have, common shareholding, and they each own 50% of the outstanding shares. That could be 100 shares, 1,000 shares, however many shares is irrelevant, but the amount of those shares that each partner owns, it kind of
Yeah.
sets that percentage that you hear. So when you have 50-50 ownership, let's use that as a really basic example, certain decisions will require, actually, you know what, for this example, let's go with 33-33, 33 for an example.
Yep.
So any one shareholder in that case cannot make something happen, cannot decide on a fundamental issue of the company because they only own 33%. Now, two of them together have 66%, and without having a shareholder agreement, they can essentially do anything because they will always have that majority shareholding. Now, there are remedies for minority shareholders if that power is abused. But generally speaking, those two shareholders have a right as a business owner to agree with each other and pass any matter of resolutions. And those resolutions dictate what the company does, how it acts, whether it's selling the company or taking on more debt or entering into a significant commercial relationship with another company. Now, what a shareholder agreement can do when we talk about control and decision making is it can limit or create situations where the company actually requires greater than what the law says what the statute says it needs to pass a resolution. So a very common aspect of a unanimous shareholder agreement is, for example, unanimous consent. So there may be very certain things like selling the business, bringing on a new investor, having a capital expenditure over $10,000, for example, that require 100% of the voting shareholders to pass. And that's a way to ensure that you don't have this situation where let's say two shareholders have a falling out with the third, that those
Yeah.
two shareholders can't kind of steamroll decisions through the company without taking into consideration the position of the third party. So, that's one example of how a shareholder can actually go beyond what the Ontario Business Corporation Act says and require, you know, more significant consent and decision making.
Okay. Okay. So, should a shareholder agreement have mediation or some sort of an arbitration kind of a clauses, uh, for potential conflict or dispute?
Yeah, absolutely. We often have, depending on the nature of the business, the shareholders, the type of capital they have, will offer a mediation clause or an arbitration clause. And then basically what that means is it says if there's a deadlock or if there's a decision in certain situations that can't be passed, but the company needs those to be something to happen in order to carry on as a business, then it will trigger, that will be a triggering event, and there will be a list of different kind of triggering events that would require the shareholders to um, go to mediation or go to binding arbitration or whatever the case may be. And that's kind of what we talked about earlier, a bit of an insurance to avoid litigation. Litigation is extremely expensive. It's extremely time consuming, and it just doesn't make sense in a lot of scenarios. So one of these clauses that you mentioned is exactly to avoid
Yeah.
litigating amongst shareholders.
Awesome. Awesome. That's an excellent point, that it's kind of an insurance, right? And it's always great to have that insurance policy, right? So Andrew, like, can you change a shareholders agreement? So let's say once you have it in place, can you refine it, retweak it, bring changes to it?
That's a good question. By virtue of being a unanimous shareholders agreement, you can't.
Yeah.
It can't be unanimous if it doesn't have all the shareholders agreeing to it. So any changes generally will require the unanimous consent of all the shareholders.
Okay.
That being
Okay.
said, there are scenarios. I have seen language in shareholder agreements that allow certain changes to be made by majority vote. Um,
Yeah.
but there is, I want to frame this like every lawyer does and qualify that statement by saying there actually hasn't been a lot of litigation, and by that I mean the courts haven't really examined those provisions a lot,
Yeah.
because
Yeah.
there's some commentary that says, if it's changed by only a majority and not unanimous, it's no longer a unanimous shareholder agreement and therefore isn't capable of being effective as a unanimous shareholder agreement. And it has to be a unanimous shareholder agreement to avail itself of some, provisions of the OBCA. So, um,
Got
and there are other commentators who would say otherwise, who say by entering into the unanimous shareholder agreement, they've entered into a contract that allows the contract to be amended with a lower level of scrutiny. So, depends. I think if a shareholder was so inclined to litigate the matter because it was changed without their knowledge or they didn't consent to it, and that change had a significant impact on them and their value of their investment, then I could see this being the type of kind of gray area that could lead to litigation. From my knowledge, currently, I haven't. There hasn't really been a cut and dry answer to whether an amendment that's not unanimous would actually have effect, even if the agreement says it does.
Even if the agreement says it does. Okay. Okay. That, that's an
Uh,
excellent point. Okay. Now, so tell me that, does the shareholder agreement will be with everyone? Let's say if a tech company is bringing in an advisor and they're giving them advisory shares, will that shareholder agreement will also be applicable in that scenario? Is it like anyone and everyone who have shares in your company have that agreement, or is it with certain partners or certain people?
Generally speaking, yes. I mean, to be a unanimous shareholder agreement, it has to be unanimous among all shareholders, period. We'll often draft a shareholder agreement that has, certain provisions that relate specifically to different classes of shares. But
Right.
if that advisory person is receiving common shares or common stock in the company, they will be a party to that shareholder agreement. Usually what we have and what a shareholder agreement usually has, or the articles may even have, or the bylaws of the company may have, is a mandatory obligation for any new shareholder to be a party to the shareholder agreement, whether they sign a document or not. We have what's called a joinder agreement, or there's other names for it, but it's a one-page document that a new shareholder usually signs to say, I've received the shareholder agreement. I acknowledge that I'm a party to the shareholder agreement. But even
Yeah.
without that, generally speaking, the articles or bylaws or the shareholder agreement itself will bind successive shareholders to that agreement. Um,
Okay.
Otherwise, it wouldn't be a unanimous shareholder agreement. Now, there are shareholder agreements that are not unanimous, but they don't have the same type of binding control over the company that a unanimous shareholder agreement does. So you may have a shareholder agreement amongst 3 of 10 shareholders because they've agreed to do certain things a certain way.
Yeah.
But that's not a unanimous shareholder agreement. And generally today we're going to be talking about unanimous shareholder agreements.
Yeah. Okay. Okay. So Andrew, explain to people, of course, like people do hear shotgun clause, and that's generally part of the shareholders agreement. So explain a little bit about shotgun clause and how companies generally use it, or how is it effective.
Yeah, no problem. Well, a shotgun clause generally, from my experience, tends to exist more in a 50-50 shareholder scenario. Um,
Hmm.
it's a essentially it's a mechanism to deal with a deadlock. So two shareholders, they own a company 50-50. They can't agree on something fundamental to the operation of the company, and it's clear that the company can't really um, carry on its business with both of them involved. So you have what's called a shotgun clause, which essentially forces the hand. It's called a shotgun clause because each person draws their gun and only one person's left standing, to put it
Yeah.
bluntly. And it's a mechanism by which one shareholder essentially offers to buy out the other shareholder at a certain price, and the other shareholder has to either accept that price
Hmm.
or agree to buy those shares at that price from the other shareholder. Uh, so let's say we're partners. I'm going to offer you $100,000 for your shares. You're going to either accept the $100,000 or you're going to buy mine for $100,000, and you have that choice. Now, when it gets interesting is when there's a power dynamic or kind of a capital difference between the partners. So let's say I'm a multi-billionaire and I know that you only have $50,000 to your name. Well, of course I can shotgun you for $100,000 because I know that even if you wanted to buy me out, let's say the company's worth 500,000, you don't have the capital to do that. So you're forced to
Hmm.
accept that $100,000. So generally speaking, a shotgun clause benefits the person with the deepest pockets. Um,
The deep.
but but it's a tool to ensure that something happens, because otherwise, both partners may be out of all their investment if they can't come to a decision. So it's kind of the harshest mechanism available
Yeah.
as far as dealing with exits of shareholders. I don't see
Yes.
them too often, to be honest. Most of the time, it's more common in 50-50 two shareholder companies. And then B, a lot of times it's just, especially in the startup space, let's say where that some of your shareholders have deep pockets, it doesn't really make sense for a founder to put that type of provision in there that could potentially allow a minority shareholder with a lot of money to force them out or shotgun them out for no reason. So, it's important that those provisions, a shotgun clause, is really well thought out. There might be sort of qualifying things that need to happen before a shareholder can actually activate that clause. So it really mechanism for forcing a transaction of the shares of the company.
Okay. Okay. Awesome. Like, before Andrew, we move forward to the next question, if you can just check in with your camera, because I think our audience cannot see it, or it seems to be frozen. So if you can just check in there, and then we move to our next question.
Weird.
Well, good, happens.
The technology, right?
Absolutely, absolutely. All the fun. Sometimes, like, it helps us realize that how much we depend on technology for each and everything.
Yeah.
And especially if something goes wrong, everything stops, right? But the good part is that like, we're still going on, and like, once you figure it out, then we can move forward. That's not an issue, right? If you have any questions, right, about shareholders agreement, anything related to shareholders agreement, go in the comment section or wherever you're watching it, right? Please make sure you go in the comment section and ask us, or reach out to us, right? I'll make sure that Andrew's direct contact link is in the show notes, and the comment section as well, so you can reach out to him if you have any questions, related to that as well. Right.
Ali, you can still hear me okay?
I can hear you perfectly. Your voice is perfect, and I think it's
I'm
just
not sure what's going on here.
yeah.
But I can kind of fiddle around in the background while we
Yeah. Oh,
carry
that,
on.
not and that's not an issue, right? That happens all the time. So I think meanwhile, Andrew, you figure it out. I'll just going to touch base on a couple of things you mentioned. That so we talked about first why shareholder agreement is important in any business, right? It's a very important element. Secondly, we talked about that in terms of shareholder agreements, what are the important components of it? So Andrew was able to touch base on important components of shareholder agreements and how you should structure it, right? We talked about arbitration mediation clauses, that how they are kind of an insurance policy when you're forming up shareholders agreement. We also talked about that irrespective of what kind of shareholders they are, they it's a common unanimous shareholder agreement, so they're part of it, irrespective, they have advisory shares or they have other class of shares, right? But it's a unanimous shareholders agreement. We also talked about changing shareholders agreement, right? How one can do it, and to touch touch base on that as well. So I think we had overall discussion about shareholders agreement, and it's I say this is one of those documents which is very critical. It's your that's where your bylaws and a lot of things stem from. So it's a very critical and important document in your business, and one should be absolute confident about what they're doing when it comes to your shareholders agreement. That has it been well thought out? Has you have taken a proper strategic advice on it, right? With a lawyer, with anyone you lean upon, your accountant, right? Because it will impact the future of your business, will directly or indirectly impact your family, the capital you have, each and everything you do in your business, right? So see
Yeah, absolutely. You're 100% right. I don't know what's. I've tried to restart the camera here. I don't know why it's not working. So
that's okay.
I
That's
guess
so.
we'll
So,
carry
meanwhile,
on.
meanwhile, Andrew, we have this is working on. Are you okay to answer the questions?
Yeah, absolutely.
Yeah. So tell me, right? What about the tax implications in the shareholders agreements?
Sorry, something just popped up here. And now I'm
The
having some
joy of
serious.
navigating the tech.
I know. I'm glad you can still hear me, but I can't move my mouse anymore, so that's great.
Interestingly, your voice is your voice is perfect. So our audience can hear you.
Okay, good. So yes, you're asking about tax implications of shareholder agreements. I'm going to be completely honest. I'm definitely not a tax expert.
Yeah.
Generally speaking, I would suggest, and this is just a recommendation for everyone listening. You really want to have and look at your lawyer as part of your team of advisors. the most successful clients I have understand what they are good at and what they're not good at, and I'm kind of putting around a team around you that can assist. So I work hand in hand with a number of accountants, depending on the nature of the business, and they're the ones that tend to kind of advise me on the tax side of things. A shareholder agreement generally deals with kind of operations of the business. Where it may have a tax implication is on how it limits the payment of dividends. And that's kind of really a unique area of the shareholder agreement, because you can kind of draft it in any way you want. For example, if your company has environmental targets. I have a client, I've worked with some clients who make that part of their mission statement, and they've said in their shareholder agreements that the company will not declare dividends, and the shareholders are agreeing that the company will not pay dividends until certain environmental targets are met. So you can really kind of limit the flow of funds to the shareholders through certain provisions detailing dividends. Another way in which a shareholder agreement may interact with tax implications is on what's called permitted assigns or permitted transferees. And what that means is, generally speaking, a shareholder agreement will limit someone from transferring their shares to someone else. There are some kind of real practical reasons for that. I don't want my partner to transfer some of their shares to someone else who I have no relationship with and now has a say in what my business is doing. So there's often restrictions on transfers of shares. Now, there are what's called permitted transferees, and common permitted transferees are family trusts, holding companies, descendants or estates. So what you may have is the shareholder agreement saying specifically, you can't transfer these shares to anybody, but you can transfer it to a family trust for the benefit of your family, a family trust in which you are a trustee of, or to a holding company in which you are the majority shareholder. And this ensures that shareholders have a certain amount of flexibility as far as tax planning their ownership of the shares goes.
So, okay. Awesome. So Andrew, let's say if someone is forming, they're about to form a shareholders agreement, what will be the most important things, some most important piece of advice you will give it to them in terms of if someone is just getting started around this?
Right. Well, I think the best piece of advice I give clients is be open and honest with your current partners. This is an agreement that will, in all likelihood, be in place for a considerable period of time. It's an agreement that everybody who is a shareholder, whether minority or majority, should have an input in developing. This agreement affects every single shareholder in different ways. And so kind of having that open and frank discussion with your partners, even though it seems like this scenario isn't possible, we love each other, this thing's going to be perfect. The reality is, these agreements wouldn't exist if that were the case. So having a really open conversation about the management of the company, about the potential growth of the company, about kind of what each investor wants to see from the corporation is really important. One of the things I like to do with clients is send them a couple articles, not even ones I've written, but I've read them, and they're, I stand behind the information of them. And what it does is it saves them on fees, because we're not going to spend 3 hours with me explaining to them what each provision means, but it helps them kind of have a base knowledge of what a shareholder agreement is, what's the purpose, what are the different types of provisions they may want to consider, and just having a high level knowledge of what a shareholder agreement is. And I think that's a good way for, a founder of a new company with not a lot of cash flow to prepare yourself for a discussion with your lawyer. And then, other than that, I would just say ask questions. Don't be afraid to ask questions. I think there's a a belief that a lot of what we do on the corporate law side is just standard precedents. And yes, every single lawyer works off some form of precedent document, but I've got, 7 or 8 shareholder agreements that precedents that I start with, depending on the nature of the company, the nature of the shareholding, the current structure, future structure, et cetera. And, you know, asking questions, having that conversation with your lawyer so you're all on the same page, understand what the purpose is, what will help us be more efficient in, starting from the right document and then tailoring it exactly to the way, it needs to be to help that company. And at the end of the day, a shareholder agreement should facilitate growth and facilitate a good relationship among shareholders. So, that's the whole point of them.
It should, like I think you made some excellent points. Firstly, the partners have to be transparent among themselves, so one can avoid future, problems. But what I like is that your approach, right? That if you work with a business, you try to educate them prior to it, so when they walk into your office or when they engage with you, right, more aware about what they're looking for. They understand, a little bit of different provisions a little bit better, right? And I think, very few clients will feel like that about a lawyer, where lawyer doesn't want to charge more. So I think that's excellent, right? And if people want to get in touch with you, how they can do that?
Yeah, absolutely. My email is andrewc@ehpnf.com. I think we'll include those in the on the post, and we'll tag that. My phone number is 416-365-7135, extension 28. I'm happy to answer any questions. I like educating my clients. I like being part of their growth process, and that's why I do what I do. So feel free to reach out if you have other questions. And yeah, I'm excited. I'm sure I'll be back on answering a new area of corporate law questions soon enough.
Absolutely. We look forward to having Andrew soon back on our show. But today's episode, if you are looking information on shareholders agreement, make sure you go and watch the whole episode. And if you have any questions which are beyond than what we talked about today, go and reach out to Andrew. He's very helpful, very open to answering questions, right? And and you will hear that, if you try to rewind back and see that how much depth he has went to in each question, because shareholder agreement is such an important piece of document which may impact you, as I said, impact your business, and it has far-reaching implications to come. Thank you so much, Andrew, for joining us today. Thank you so much, everyone, for joining us today. We'll catch you soon in the next episode. Have a good day. I'm Saini from Lawcheek, and you're watching the Legal Connect podcast. Thank you.
Thanks, Ali. Take care.